Custody process is one of the most important components of a divorce case. Our goal at the end of your case is to set you and your children up for success. In both state of Kansas and state of Missouri, we have joint legal custody and sole legal custody. Sole legal custody means that one parent can make the major life decisions for the life of your children. That includes medical decisions, that includes educational decisions, or anything that majorly impacts our life. Joint legal custody, on the other end, means that you and your spouse have to put your differences aside, co-parent, and together make those major life decisions for the life of your children. Now, the process is a little different in Kansas versus Missouri. On the Missouri side, we have now a presumption of joint legal custody as well as a presumption of equal or near equal parenting time. On the Kansas side, we do not, but the most important thing to bear in mind is that there is one standard that's applied across the board, and that's the best interest of the minor child. At the end of the case, ultimately, the court's going to look at what's best for these children, and that's what the court's going to order.
Whether you're in Kansas or Missouri, custody cases typically start with the filing of a petition. If you're filing a divorce petition, custody automatically comes along with that. If you've never been married, then you'd be filing something called a paternity action. Now, when our firm looks at custody issues, we start by looking at where is there agreement to the parties. We try not to focus on what you're arguing about, but where do we have agreement? Because what we're trying to do is craft a temporary custody and visitation plan that's going to work for the kids and set you guys up for success later. If we can't work something like that out, then we'll go to the court and ask for a temporary order relating to custody and visitation. That's not the ideal because this is a judge who doesn't really know that much about your family, but still the order would be put into place and it would dictate what kind of custody you have and what the visitation schedule is while the case is pending. Now, once you're through temporary orders, there's a lot of different things that can happen, a lot of different services depending on what state you're in and what county you're in. These can include things like child custody, evaluators, mediation, and a host of other services. Now, if you're in a situation that's really extreme, the court might appoint somebody called a guardian ad litem. That's actually an attorney who's representing your child. That means that you have issues that are so extreme that your child needs their attorney to advocate for them. So you can imagine the level of animosity that has to happen. That's not in every case. It's fairly rare, but that can happen. As you go through this custody process, it's really important for you to be present and thinking about what this is going to look like down the line as you get through your divorce and you have all these years together where you're still co-parenting your child. Now, regardless of what happens with the custody, whether it's resolved through a settlement process or through trial, the last thing that will happen in your case, or what will happen in every case, is that you will end up with a detailed parenting plan.
One thing that's for certain at the end of a divorce process is that you and your former spouse will continue to co-parent your minor children until they turn 18 years old. Now, whether you got divorced when they were just 2 or whether you got divorced when they were 16, having a detailed and precise parenting plan that outlines issues with school, that outlines issues with a holiday schedule, with regular parenting time schedule, with unforeseen circumstances that might happen during each parent's parenting time, with reimbursement of medical expenses, with extracurricular activities and so forth, is vital because it will guarantee a successful co-parenting until these children turn 18.
A lot of our clients will ask us whether their children should be in therapy during the divorce process or even after the process. My answer to that question is almost always yes, and here's why. It's very clear from the research that the divorce process hurts kids. Even an amicable divorce is going to take some kind of toll on your child. And the more confrontational, the more adversarial you are, the more damage you're going to do to that child. Now, the court may order this anyway during the pendency of the case. They may have your child go to therapy. They may have you all go to therapy. They may order you individually into therapy. But regardless of that, as parents, you can make that decision. It is a decision that should be made together. You should both be able to participate. And what I mean by that is each one of you should from time to time take the child to their therapy appointments. Because remember the goal here, it's not to win, it is to set your child up to have a healthy and successful life long after your divorce is ever over. And I think counseling or therapy can be very critical to that.